of negative judicial review that we are seeking, striking down an unconstitutional exception. This is not an economic statute, my lords. My lords, this is not an economic statute, and my lords have made that distinction.
What do you have to say to this argument that by striking down the exception, and we're not putting it, we're just putting it as a theoretical construct, that striking down the exception and criminalizing acts of non-consensual intercourse within the fold of marriage would have the possibility of destabilizing the institution of marriage. What's the answer to that? Because that's something which they have said in their counter affidavit.
My lords, para 90 may be of assistance here.
Para?
5743, my lord. That was Justice Deepak Gupta. This is Justice Lokul.
Para 90.
Yes. 5743 of the PDF. Do my lords have it?
Yes.
The view that marital rape of a girl child has the potential of destroying the institution of marriage cannot be accepted. Marriage is not institutional, but personal. Nothing can destroy the institution of marriage except a statute that makes marriage illegal and punishable. A divorce may destroy a marriage, but does it have the potential to destroy the institution of marriage? A judicial separation may dent a marital relationship, but does it have the potential of destroying the institution of marriage or even the marriage? Can it be said that no divorce should be permitted or that judicial separation should be prohibited? The answer is quite obvious. My lords, Joseph Shine also deals with this aspect. This is PDF 7213.
Yes.
Where is it? My lords, this is 192, my lords. It's in the middle of the page. The right of privacy depends on the...
What? Para 192?
192, my lords.
Where do you get that? Page?
7213 of the PDF of the judgment compilation where you were reading independent thought.
Yes. 7213 is the printed page 7203. 7203 is a printed page on the right-hand side. So which line, Placidum?
192, my lords, Placidum E.
192. So something different there. The page begins with the words, which abolishes untouchability?
No, my lord.
What is the printed
PDF 7213 and the printed page is...
No, we've got PDF 7213.
No.
You're reading Indian Lawyers Association, Indian Young Lawyers Association.
I'm reading Joseph Shine, my lord.
Where does Joseph Shine begin? No, then that's not the judgment.
This is the common compilation of judgments.
All right, just one second. We'll just tell you where it is.
Joseph Shine is 6779. That is PDF 6789. Come to 6789.
My lords, clearly there's a disjunct and we'll make sure.
Doesn't matter. Come to 6789 PDF.
789. That's Navte Johar, my lords, in our compilation.
And
but
which
you,
para,
my lords,
which
have
para are you
para
referring
192.
Para 192.
Please consent.
Can you tell us the page of the report, the law report, the right-hand corner?
158, my lord.
158. It will be 6898, I think. 6 find it.
Let's fix it now.
There are 192, right?
Yes, ma'am.
Okay, the right to privacy depends on the exercise
Yes.
of autonomy.
Do my lords have it now?
Yes.
The right to privacy depends on the exercise of autonomy and agency by individuals. In situations where citizens are disabled from exercising these essential attributes, courts must step in to ensure that dignity is realized in the fullest sense. Familial structures cannot be regarded as private spaces where constitutional rights are violated. To grant immunity in situations when rights of individuals are in siege is to obstruct the unfolding vision of the Constitution. The opinion delivered on behalf of 4 judges in K.S. Puttaswamy versus the Union of India has recognized the dangers of the use of privacy as a veneer for patriarchal domination and abuse of women, on the delicate balance between the competing interests of protecting privacy as well as dignity of women in the domestic sphere. The challenge in this area is to enable the state to take the violation of the dignity of women in the domestic sphere seriously, while at the same time protecting the privacy entitlements of women grounded in the identity of gender and liberty. In Seeing as like a Feminist, Nivedita Menon has recognized the patriarchal family as the basis for the secondary status of women in society. Menon notes that the personal is political. Her scholarly work implores us to recognize spaces which may be considered personal, such as the bedroom and the kitchen. These spaces are immersed in power relations, but with ramifications for the public sphere. Control over women's sexuality is the key patriarchal assumption that underlies family and marriage. When it shifts to the public as opposed to the private, the misogyny becomes even more pronounced. Section 497 embodies this. By the operation of the provision, women's sexuality is sought to be controlled in a number of ways. First, the husband, and he alone, is enabled to prosecute the man with whom his wife has sexual relations, even in cases where the relationship is based on the consent of the woman. The law treats it as an offense, denying a woman who has voluntarily entered into a consensual relationship of her sexual agency. Second, such a relationship would be beyond the reach of penal law if her husband consents to it. The second condition is the telling reflection of the patriarchal assumption underlying the criminal provision, that the husband is the owner of the wife's sexual agency. In remedying injustices, the court cannot shy away from delving into the personal and, as a consequence, the public. It becomes imperative for us to intervene when structures of injustice and persecution deeply entrenched in patriarchy are destructive of constitutional freedom. But in adjudicating on the rights of women, the court is not taking on a paternalistic role and granting rights. The court is merely interpreting the text of the Constitution to restate what is already set in ink. Women are equal citizens of this nation, entitled to the protections of the Constitution. Any legislation which results in the denial of these constitutional guarantees to women cannot pass the test of constitutionality. Patriarchy and paternalism are the underpinnings of Section 497. It needs no iteration. It needs no iteration that misogyny and patriarchal notions of sexual control find no place in a constitutional order, which has recognized dignity as intrinsic to a person, autonomy being an essential component of this right. The operation of Section 497 denotes that adulterous women virtually exercising no agency, or at least not enough agency to make them criminally liable, they are constructed as victims. As victims, they are to be protected by being exempt from sanctions of a criminal nature. Not only is there a denial of sexual agency, women are also not seen to be harmed by the offense. Thus, the provision is not simply about protecting the sanctity of the marital relationship, it's also about protecting a husband's interest in his exclusive access to his sexuality. My lords, 182 might also...
Read 199.
199, then 200 also.
199.
In Navtej, one of us, as my lord then was, Chandrachud, held that the recognition of the autonomy of an individual is an acknowledgement of the state's respect for the capacity of the individual to make individual choices. The right to privacy enables an individual to exercise his or her autonomy away from the glare of societal expectations. The realization of the human personality is dependent on the autonomy of an individual. In a liberal democracy, recognition of the individual as an autonomous person is an acknowledgement of the state's respect for the capacity of the individual to make independent choices. The right to privacy may be construed to signify that not only are certain acts no longer immoral, but there also exists an affirmative moral right to do them. To characterize a woman as a passive object, denuded of agency, is a denial of autonomy. The same judgment in Navtej has recognized sexual choices as an essential attribute of autonomy, intimately connected to the self-respect of the individual. In order to understand how sexual choices are an essential attribute of autonomy, it is useful to refer to John Rawls's theory on social contract. Rawls's conception of the original position serves as a constructive model to illustrate the notion of choice behind a partial veil of ignorance. Persons behind the veil are assumed to be rational and mutually disinterested individuals unaware of their positions in society. The strategy employed by Rawls is to focus on a category of goods which an individual would desire, irrespective of what individual's conception of good might be. These neutrally desirable goods are described by Rawls as primary social goods and may be listed as rights, liberties, powers, opportunities, income, wealth, and the constituents of self-respect. Rawls's conception of self-respect as a primary human good is intimately connected to the idea of autonomy. Self-respect is founded on an individual's ability to exercise her native capacities in a competent manner. Marriage as a social institution has undergone changes, propelled by access to education and by economic and social progress. Women have found greater freedom to assert their choices and preferences. The law must also reflect their status as equals in a marriage, entitled to the constitutional guarantees of privacy and dignity. The opinion delivered on behalf of 4 judges in Puttaswamy held thus: as society evolves, so must constitutional doctrine. The institutions which the Constitution has created must adapt flexibly to meet the challenges in a rapidly growing knowledge economy. Above all, constitutional interpretation is but a process in achieving justice, liberty, and dignity of all citizens. In Navtej, Rohinton Nariman J. countered the assertion that the court must not indulge in taking upon itself the guardianship of changing social mores by holding thus: the very purpose of the Fundamental Rights chapter in the Constitution of India is to withdraw the subject of liberty and dignity of the individual and place such subject beyond the reach of majoritarian governments, so that constitutional morality can be applied by this court to give effect to the rights among others of discrete and insular minorities. One such minority has knocked on the doors of this court, as this court is the custodian of the fundamental rights of citizens. These fundamental rights do not depend upon the outcome of elections, and it is not left to majoritarian governments to prescribe what shall be orthodox in matters concerning social morality. The Fundamental Rights chapter is like the North Star in the universe of constitutionalism. In India, constitutional morality always trumps any imposition of a particular view of social morality by shifting and different majoritarian regimes. Section 497 seeks the preservation of a construct of marriage in which female fidelity is enforced by the letter of the law and by the coercive authority of the state. Such a conception goes against the spirit of the rights-based jurisprudence of this court, which seeks to protect the dignity of an individual and her intimate personal choices. It cannot be held that these rights cease to exist once the woman enters into a marriage. I'll just read the first line of 203, and then I'll move on to another part of Joseph Steinmüller's, which will also be squarely applicable. The identity of the woman must be as an individual in her own right. In that sense, her identity does not get submerged as a result of her marriage. My lords, para 182 will also be of assistance. This is Law Report, page 155. My lords have it? My lords have?
Yeah.
Implicit in seeking to privilege the fidelity of a woman in marriage is the assumption that a woman contracts away her sexual agency when entering a marriage.
Where are you reading?
My lords, this is para 182. This is paper book, page 7200. My lords, Justice Pardiwala, you have it? Implicit in seeking to privilege the fidelity of woman in a marriage is the assumption that a woman contracts away her sexual agency when entering into a marriage. That a woman, by marriage, consents in advance to sexual relations with her husband or to refrain from sexual relations outside marriage without the permission of her husband is offensive to liberty and dignity. Such a notion has no place in the constitutional order. Sexual autonomy constitutes an inviolable core of the dignity of every individual. At the heart of the constitutional rights guaranteed to every individual is a primacy of choice and the freedom to determine one's actions. Curtailing the sexual autonomy of a woman or presuming the lack of consent once she enters a marriage is antithetical to constitutional values. Para 168? 72054? It's at page Porter and 7195.
Original.
Lords?
Yes.
My Lords, at paragraph 168, which is at reporter page 150 and paper book page 7195. Where is this? The hypothesis which forms the basis of the law on adultery is the subsistence of a patriarchal order. So section 497 is based on a notion of morality which fails to accord with the values on which the Constitution is founded. The freedoms which the Constitution guarantees inhere in men and women alike. In enacting section 497, the legislature made an ostensible effort to protect the institution of marriage. Ostensible it is because the provision postulates a notion of marriage which subverts the equality of spouses. Marriage in a constitutional regime is founded on the equality of and between spouses. Each of them is entitled to the same liberty, which Part 3 guarantees. Check the paragraph she has. Okay. This is the end of the provision. Shall I proceed, my lords? Marriage in a constitutional regime is founded on the equality of and between spouses. Each of them is entitled to the same liberty, which Part 3 guarantees. Each of them is entitled to take decisions in accordance with his and her conscience, and each must have the ability to pursue the human desire for fulfillment. Section 497 is based on the understanding that marriage submerges the identity of the woman. It is based on a notion of marital subordination. In recognizing, accepting, and enforcing these notions, Section 497 is inconsistent with the ethos of the Constitution. Section 497 treats a woman as but a possession of her spouse. The essential values on which the Constitution is founded, liberty, dignity, and equality, cannot allow such a view of marriage. Section 497 suffers from manifest arbitrariness. While in grafting the provision into Chapter 20 of the Penal Code of offences relating to marriage, the legislature has based the offence on an implicit assumption about marriage. The notion which the law propounds and to which it imposes the sanctions of penal law is that the marital tie subordinates the role and position of the woman. In that view of marriage, the woman is bereft of the ability to decide, to make choices, and give free expression to her personality. Human sexuality is an essential aspect of identity. Choices in matters of sexuality are reflective of the human desire for expression. Sexuality cannot be construed purely as a physiological attribute. In its associational attributes, it links up with the human desire to be intimate with a person of one's choice. Sharing of physical intimacies is a reflection of choice in allowing individuals to make those choices in a consensual sphere. The Constitution acknowledges that even in the most private of zones, the individual must have the ability to make essential decisions. Sexuality cannot be disassociated from the human personality, for to be human involves the ability to fulfill sexual desires in the pursuit of happiness. Autonomy in matters of sexuality is thus intrinsic to a dignified human existence. Human dignity both recognizes and protects the autonomy of the individual in making sexual choices. The sexual choices of an individual cannot obviously be imposed on others in society and are premised on a voluntary acceptance by consenting parties. Section 497 denudes the woman of the ability to make these fundamental choices. in postulating that it is only the man in a marital relationship who can consent to his spouse having sexual intercourse with another. Section 497 disregards the sexual autonomy which every woman possesses as a necessary condition of her existence. Far from being an equal partner in an equal relationship, she is subjugated entirely to the will of her spouse. The provision is proffered by the legislature as an effort to protect the institution of marriage. But it proceeds on a notion of marriage which is one-sided and which denies agency to the woman in a marital tie. The ability to make choices within marriage and on every aspect concerning it is a facet of human liberty and dignity which the Constitution protects. In depriving the woman of the ability and recognizing it in the man alone, Section 497 fails to meet the essence of substantive equality in its application to marriage. Equality of rights and entitlements between parties to a marriage is crucial to preserve the values of the Constitution. Section 497 offends that substantive sense of equality, and it is violative of Article 14. No, fair labeling. Of the Constitution that my lords have recognized in Joseph Shine are the pillars that we seek to base our arguments on.
All right. Now, apart from this, what else do you want to show?
I would like to address the question that had fallen from my lords on fair labeling.
Fair?
Fair labeling. Fair labeling of a criminal statute. So, independent thought deals with that. Okay? Paper book. My lords, this is a judgment paper book, 5725.
Another 15 minutes and we'll wrap up. Then we'll give Mr. Shankar Narayan another.
My lords, I may just need a few more minutes than that just to point where my various other arguments are. My lords, para 73. Para 73 of independent thought. This is at 5725 and page 863 of the reporter. Now let's have it.
Yes.
On a combined reading of CR versus UK and Eisenstadt and Baird, it is quite clear that a rapist remains a rapist and a marriage with the victim does not convert him into a non-rapist. Similarly, a rape is a rape, whether it is described as such or is described as penetrative sexual assault or aggravated penetrative sexual assault. A rape that actually occurs cannot legislatively be simply wished away or legislatively denied as non-existent. My lords, with regard to fair labeling, if I may go to my table of statutes, because their essential argument and Justice Harishankar's argument at its highest essentially says that the legislature, perhaps having wished away the idea that rape in the context of marriage is not rape, has otherwise provided for the prosecution of the offence under other sections. So let us look at the primary section that they cite, which is the erstwhile 498A and the current section 85. The husband or relative of a husband of a woman subjecting her to cruelty. Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. So what they've done is that they've split up 498A, and the second part is in 86 BNS, otherwise it's been wholly retained. Here they define cruelty. Cruelty is not rape. Cruelty, for the purposes of section 85, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, whether mental or physical. Where is it? I beg your pardon. Or harassment of the woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is account of failure by her or any person related to her to meet such demand. So the second part is related to dowry. And if you are raping someone in relation to dowry, then that might kick in. The first part is in relation to rape, but only that rape that will drive her to suicide. So if that rape doesn't drive her to suicide, or is of other such extreme cruelty, then it's not covered by 498A. Now, similarly, old section 323, if there is simple hurt, then it does not cover what are the actual ingredients of rape, which is penetrative intercourse against the person's will or consent. So therefore, the concomitant crimes are punishable. And the courts are acting in that regard. So when there is a rape that happens outside of the context of marriage, very frequently, you will also have 498A. I beg your pardon, 323. Or you will have 326.
Exactly.
Offences are punished even within the fold of marriage.
Yes.
Take a case. The husband demands, wife declines. We just envisage a situation.
Yes.
Husband goes to the extent of confining his wife in a room. That's wrongful confinement. Then he threatens her. That's administration of threats.
503, 506.
Criminal intimidation. Then he starts assaulting her. It could result in simple hurt. It could result in grievous hurt. At the end of it, the lady succumbs. Correct? The act is completed. So 323, 324, 325, 326, as the case may be, prima facie committed. Wrongful confinement, 352, I don't know about BNS, committed. Criminal intimidation, committed. All this being committed for what purpose? That the wife succumbs.
Yes.
But the last part of his act excludes him. It doesn't constitute an offense because he happens to be the husband. So perhaps your line of argument is that if these are the acts which constitutes an offense, even during the marital tie, be it husband, wife, then why this exception? Because He did all this because he wanted this. I'm just putting it in a simple language, not
That's exactly, that's
very
exactly
elaborate.
my point, my lords, yeah.
So that's what you want to convey.
My lords, if I may take that one step beyond the act of succumbing. If she says no and the intercourse happens, then all of the provisions my lord cited will apply, but 375 or section 63 of the BNS will not apply because he's the husband. Then if he kills her, that will apply.
This word no is something which will hear the other side also.
Yes.
We are at present envisaging a situation where the husband goes to this extent. He goes to this extent, assaulting his wife, behaving rudely. That would constitute everything, 498A, 323, 325, 326, if it results in grievous hurt. But when the final act is committed, you say, you will be prosecuted for all these offenses, but you cannot be prosecuted for this. Now take a case where nothing of this happens. Husband says, I demand. Lady says, wife says, no. Then what?
That would be exempt under the exception, my lords.
Correct. So how do you perceive this no from the wife? When it comes to marital relationship, it is the husband who is demanding, wife is in no mood, is declining. She believes that my husband should not have done this. This is forcible act. How do you perceive that?
My lords, the impugned judgment.
And on the next day, she goes and lodges a FIR. But this is what happened.
My lord, what is falling from my lord?
We want We want your assistance on this.
Feeds into the Article 19(1)A argument, which is that currently my right to say no takes away my right to also say a free and joyful yes. Because I have been reduced by this exception to a legal subject and a sexual object.
So your argument is that if it is no, the only option for the husband is to go for divorce.
My lords, he may go for divorce. He may wait till the next day. My lords, he may be more charming. He may talk to me. Do you have a headache? That's all. He may say, do you think you might change your mind? Oh, my lord. My lords, while we're on 19(1)(a), on this alone, the provision can be struck down. The reason is also, in addition, that the 19(2) categories does not cover this. Categories are the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, which my lords have read in Khushbu versus Kaniyammal, but also morality as constitutional morality, or in relation to contempt of court, defamation, or incitement to an offence.
Okay. Anything else now? So we can call upon someone else.
Yes, my lord. My lord, I will then just point in, if my lords have my short note,
Yes.
I will then point to the remaining argument in Article 14, which is that, and this is in my written submissions, but I'll also seek leave to file other written submissions, but that an entire protective regime of the victim as well as the accused is triggered once the word rape comes into play. For example, for the victim, her identity will be protected, as we have been dealing with, my lords, in some of the other cases, Narji Court, under Section 228A. She will get immediate medical care. She will be assisted by a woman police officer, etc. Yes, there will be compensation. But in addition, the accused also actually has some protections, because old Section 53A says, which has its identical equivalent in the BNSS. The examination of person accused of rape by medical practitioner, that also kicks in. When a person is arrested on a charge of committing an offense of rape or an attempt to commit rape, and there are reasonable grounds for believing that an examination of his person will afford evidence as to the commission of such offense, it shall be lawful for a registered medical practitioner employed in a hospital run by a government or local authority. And in the
That's okay, we'll look at your submissions.
Yes, my lords. My lords, to sum up Article 15 also, Article 15 is dealt with in Joseph Shine and Navdeep Johar, the stereotypical conception of gender roles. My lord, if I
may... It is also dealt with in Anuj Garg also.
It cites Anuj Garg. Yes. My lords have in fact cited Anuj Garg in...
I've followed Anuj Garg in the other judgments, Shine and... Yeah.
You would follow it, my lord. My lords, the Constitution is transforming and us citizens are transforming with it. As Maya Angelou said, once you know better, do better. The criminal law is not retroactive, it is prospective. So therefore, if we are all living together, and if there is a society of men that thought this was legitimate, then it may not apply to them. It may only apply going forward, number one. Number two, this case, if I may be very clear, is not about men versus women. This is people versus patriarchy. And this is why we have come to our courts. And also there is an affidavit of the Forum for Engagement of Men, a recognized, long-standing men's rights group, a set of men's rights groups.
You have argued the constitutional issue. We need not go into that. We'll leave it at that.
Yes.
Thank you, Ms. Nandi. Thank you.
I'm grateful.
Mr. Shankaranarayan is going to argue now.
My lords, I have a few more points. I have a few more points, so I can just place them and then Mr. Shankaranarayan.
We look at them from your, they're all in your submissions, right?
I will place other written submissions, but my lords, in terms of the petitioners,
all right.
There is us, there is Mr. Shankaranarayanan, and in that table...
You suddenly distorted his name, Shankar Narayan.
Shankaranarayanan.
Oh, yes, okay.
Mr. Shankaranarayanan. I've known him for 20 years, my lords. We are all friends with him. And Mr. Colin Gonsalves, and then Ms. Jai Singh on interpretation. Now, a number of men's rights associations, my lords.
Fair enough. Don't worry about them. When their turn comes, we'll hear them.
But they are interveners.
Right.
So,
now,
and they're against us.
Sai Deepak, you are supporting what is...
Against.
I mean, I'll just.
Are you supporting what she has said or no?
I represents the Men's Welfare Trust, which is item number 8.5.
Fair enough. No difficulty. If you are
They are
hearing,
done.
but since we are hearing one line of arguments, it will be much better.
It just so happens that the Delhi High Court judgment is based on Ms. Nandi's submissions in line, so which is one of the reasons that I would only
And
request my lords to
for
keep
Mr.
this-
Gonsalves and others, many others, my lords.
Of course.
Wait,
May I mention one thing, my lord? There was a,
Now, you are supporting Ms. Nandita.
I'm with Mr. Shankar Narayanan. I'm just
You start. We are not going to wait for anybody. You now start.
my lord, I just want to point.
Who else is on this side? Who else is on this side? If there's somebody else who is filling in the breach there, then we don't mind somebody else arguing for
There's
it.
Mr. Gonsalves and then there's, yes, he's here. He was before the High Court in the civil appeal.
All right.
This is the Khushbu set.
Gonsalves, we'll request you not to cover the ground which Karuna has already.
Yes, I'll not do that, my lord. But I want to take you straight to my written arguments. And without reading it, I'll tell your lordship what's there.
वो करुणा नंदी जी का जो रिटन सबमिशन है Ms. Nandi, your written submissions were in serial number 7. All right. Yes, Mr. Gonsalves.
Yes, my lord. I'll only tell your lordship what is there in the written
Where
argument.
do we get your submissions, Mr. Gonsalves?
That is, my lord, in the, it's in Civil Appeal 5858.
Which one?
No,
is
sorry,
that?
Civil Appeal 6787
Where
of
should we-
2022, which is
The item number?
40.2,
Item number?
8.2.
8.2.
Yes, my lord.
But where do we get your submissions, Mr. Gonsalves?
Page 1 of the,
No, but where are they filed? Notary council would have
in the
filed
Civil
them.
Appeal.
According to Ms. Jadeja, they weren't served, so they never couldn't file.
Oh,
So I don't think there's a digital copy of it before your
we have
lordship.
served it to Ms. Jadeja because she's been doing this meticulous job of putting everything together.
So therefore, she requests,
Otherwise, while dictating the judgment, it becomes almost impossible to sort of wade through. If you have one digital file, it becomes so much easier.
submissions were not there, so Ms. Jadeja couldn't file.
Where are the submissions, Mr. Gonsalves?
Page 1 of the Civil Appeal, in the synopsis I set out.
Oh, okay, one second.
The written, yes, my lord.
8.2, you mean the synopsis will have it?
Yes, my lord. It's the submissions of the,
Additional.
where is it?
Thank you, Vishen.
It's a compilation of written submissions and judgments. Compilation of written submission and judgments. Submissions on behalf of the petition.
Yes, we got that.
Lordship has that?
Got it.
Submissions on behalf of the petitioner dated 4th of March 23.
Yes.
Turn to page 1, my lord. And I'll tell your lordship rapidly what it contains. Lordship has page 1?
Yes.
Yes. So, my lord, the other cases are public interest cases. This is a marital rape victim, page 1. Suffered abuse and assault and all that, followed by
We
rape.
didn't go into facts. We
No,
won't.
no, I'm not going into facts. I'm not going into facts at all. Then, my lord, the issues I've outlined at page number 2, that the exception is arbitrary and unconstitutional. I won't read this out, but there are 12 issues that I've outlined. Then, my lord, at the bottom of page 3,
Are there
I start with the observations in the impugned order on marital rape.
Impugned order means what?
In the order of, my lord, the judge who said that it cannot be done. The exception cannot be set aside. The exception is valid.
That is, you are relying on Justice
Hari Shankar.
Shankar's view.
So what is wrong in that, my lord? These are the observations.
Impugned order as such.
It's the impugned order. Correct, my lord. Where the judge says basically,
My
well, my lord,
courtmaster says that nobody except Ms. Jaising has emailed their submissions, because please make sure that you email the submissions to Jagriti, because otherwise, she will put it together for us by the evening.
yeah, you know what is it.
We filed our written submissions, my lord.
जैसे we have yours, इनका भी है, करुणा नंदी जी का भी है.
दोनों matters में है, my lords.
All of you, if you can just email your submissions to Jakriti Jadeja, so then she can put one file, electronic file for us.
Done, my lords.
By this evening.
Yes.
Yes,
My lords may set a deadline on it. We'll do it by
By
tomorrow.
evening, give it to her by say 6 o'clock in the evening.
We'll do it by 6 o'clock today.
So, well, paragraph 2 are the suggested issues before the court.
And Ms. Jadeja, what you can do is you can then email it to the court master. So we'll have 3 copies. We'll have copies for each of us by tomorrow of one compilation. Yes.
So, well, paragraph page 3.
Mr. Sai Deepak, are you also filing a short note, 5 pages or so? You filed it, no? Make sure that you just email it to Jakriti so that, it will be part of one compilation, so we don't have to look here and there.
Yes. So, my lord, paragraph 2, page 2, my lord, is the suggested issues for consideration.
Okay,
by the
then-
court. Page 3, from the bottom of the page are the observations in Justice
Harishankar's order.
Hari Shankar's judgment, where he basically says a man is protected completely. And it is absurd to think of including a married man as liable for rape within the institution of marriage. Now, my lord, page 5 onwards. And my lord, I put it right up front because the judgments of the superior courts in at least 6 or 7 jurisdictions deal with the same issues, come to the conclusion that the exclusion is not constitutional, and there's really no need, my lord. Before the High Court, I took exactly, my lord, an hour or so to finish the arguments because the judgments are very exhaustive. So we start with England and Wales on page, my lord, 5. Then your lordship will go to page 11, which is Canada. Then, my lord, will go to, my lord, page 12, which is South Africa and Australia. Page 13 is the United States. Page 17 is Thailand and Nepal. And, my lord, I must just tell your lordship about Nepal, because they answered the question squarely. Does it degrade the institution of marriage to have a provision which penalizes the husband? And the Nepal Supreme Court, my lord, at page, I'll give your lordship that page, at page 23, very nicely answers the question, saying it is precisely the opposite. Having violence and rape within marriage degrades the institution of marriage. And penalizing it, criminalizing it, actually purifies the institution of marriage. Very nice answer, my lord, by the Constitutional Court. Then, my lord, at page 24 and 25 is France, Germany, Belgium, Netherlands, Italy. So now right across the world, you have constitutional judgments, setting aside, my lord, this exception too. Then, my lord, from 25 onwards are the international conventions, which specifically say, my lord, that marital rape is rape. Page 27 is the recommendations of the Justice Verma Committee. Page 29 onwards, my lord, in response to an argument made, my lord, by the government before the High Court, that this is a Western concept, and that, my lord, is not true in India, etc., etc. We have attached, my lord, 2 UN reports, where, my lord, in UP, Rajasthan, Haryana, men were interviewed on whether they have sex with their wife even when their wife say no. And startling statistics emerged, showing that 40% of men openly say, yes, we do, and it's not a problem at all. Then, my lord, at page 31 is the UK Law Commission report, which we used in the High Court, my lord, to answer the objection taken by the central government that once you make it a crime wives will litigate against husbands.
Only one clarification. Central government didn't argue before the High Court. I think my learned friend seems to be under a wrong notion because he keeps on
Anyway.
saying that to meet with this contention, to meet with that contention. We never argued before the.
All right. So, my lord, this is page 31. Leave it.
It can't be.
My lord, it will result in chaos. There'll be a floodgate opening of litigation by wives against their husbands. It'll be impossible to prove. The Law Commission dealt with that it happens within the confines of a room, a bedroom in privacy. It'll be impossible to prove. So the Law Commission deals with that argument as well.
Where do we get that?
That is, my lord, page 31 is the UK Law Commission working paper, Rape Within Marriage. And this was commissioned, my lord, after the House of Lords, my lord, held it to be unconstitutional and did away with the exception that Lord Hale had instituted, my lord, hundreds of years back. So, my lord, that is. Now, my lord, at page 38 onwards. Are my submissions, my lord, in respect of the justifications for retention of exception 2. And the question was raised as to was the legislature right in providing all married men criminal immunity against their wives in rape cases? Number 3, whether the Constitutional Court, while deciding the issue of constitutionality, also look into the issues of difficulties that will arise in proving rape within the confines of it, etc., etc. And the general, my lord, consensus of the courts are that once we declare the law and hold that the exception is not valid, then, my lord, the law will have to work itself out and by practice, my lord, sort out how. My lord, in the case of a husband raping his wife, how prosecution will be done. That is, my lord, 3940 onwards. Then, my lord, at page 42, we dealt with an objection taken. See, that matrimonial rape argument that somehow in a marital relationship, if rape takes place, the punishment should be less than the punishment for rape generally. Page 41. And, my lord, what the courts have said about that. Then, my lord, page 42. We dealt with the argument that 498A exists, other punishments exist for other crimes connected with rape. Therefore, that is good enough, and it is not necessary for India to go the route of criminalizing. Then, my lord, false cases at page 43. The argument that it's 43, and it became, the argument used was, it would be, middle of page 43, it would be an easy tool for harassing husbands. Floodgates of false cases would be made, etc., etc., etc. Then, my lord, the page 44 was the argument made. 44. 44. This might have, my lord, some connection with my Lord Justice Paradiwala's question, but and I want to answer that straight away. The argument was made before the High Court that a husband has a right to expect sex. And perhaps that might be correct to some extent, but to answer your lordship's question, a wife may be unreasonable. She may say no. Let us take it that it is unreasonable that she said no. But once a wife says no to a husband who says, I want to have sex, and assuming that she's being unreasonable, in all situations, once a woman tells her husband no, it becomes a no.
It becomes a
No.
no.
There is no exception to that. And your lordship asks, can she go and file an FIR against her husband if there is rape within the marital home? The answer is yes. And right across the world, if a woman says no, it is no.
Okay,
Yeah.
come to section 67.
Yes, ma'am.
Assist us on this short point.
Yes, ma'am.
Again, I am putting a hypothetical.
Yes, ma'am.
right?
I understand. Yes.
You said no, correct? A big
Yes,
no.
ma'am. Yes.
She is tired. And one fine day, she decides to leave her matrimonial home
Yes, ma'am.
and goes back to her parental home.
Yes, ma'am.
Or she goes to anybody else's residence.
Yes, ma'am.
What do you mean by under a degree of separation or otherwise? How do you construe this word otherwise in section 67? Because
Yes, ma'am.
it constitutes an offense.
Even within the fold of marriage.
Even within the fold of marriage,
Yes, ma'am.
legislature has thought fit to say sexual intercourse by husband upon his wife during separation.
Yes, ma'am.
But the statute, the provision says whether under a decree of separation, one can understand.
Yes, or otherwise.
There is a decree of divorce,
Yeah.
everything goes.
Yes, ma'am.
They cease to be husband and wife.
Yes, ma'am.
If even there is a decree of separation,
Yes, ma'am.
which is distinct from a decree of divorce.
Correct, ma'am.
But what do you mean by or otherwise?
That means, my lord, if there is no decree of separation, but the wife is living separately, in fact,
That's your argument.
that's my argument, my lord. The wife has separated, she's moved to a place, she's living separately, they've not yet got a degree of separation. And then the husband says, listen, I'm still married to you.
Offense as long as she is at her matrimonial home.
No, my lord, I'm not saying that. I'm saying that wherever the wife may be, if she says, yeah,
See, 67, this question would not have cropped up. The legislature in its wisdom has thought fit to make this an offense. That if
Yes.
a husband has sexual intercourse, because you see the heading, sexual intercourse by husband upon his wife during separation.
yes, ma'am.
What do you mean by separation?
What I mean by separation is, my lord, if the court says, yeah,
Question.
yes,
When the provision says decree of separation,
yes, ma'am.
is the marriage still subsisting or it's just a decree of separation? For a couple of months, the spouses will live at a different place. They will not reside together. In 67, whether the marriage still continues, subsists or not.
It may subsist, my lord. It doesn't matter really. If it's a divorce and the separation is permanent, that's separate.
Before divorce
Yes.
stands on a
In fact,
different.
Yes,
footing.
she's separated. Yes,
67 postulates that the marriage is subsisting.
correct.
Because it says
Husband,
with
Yes.
his wife.
Yes, my lord. So you're separate, but your marriage is intact. Now the husband forces himself on the wife when you all are separate, but your marriage is still intact.
So even within the fold of marriage, 67 postulates that there could be a rape.
Yes, of course, my lord. It's an absolute no, my lord. Now, the argument is a practical one, and that's why the Law Commission report, which I
Now, the
read out.
difference between 67 and exception 2 is that exception 2 applies in a situation where they are not living separately. They are living together, but she has said no for that particular act of sexual
Yes,
intercourse.
yes,
67 applies to a situation where they are living separately.
yes,
Living separately means that, well, there's no intention now to cohabit together.
yes,
It has to be ejusdem generis. Brother Mishra just said it has to be read ejusdem generis.
yes,
As in the case of a decree for judicial separation, where the postulate is that you're not going to cohabit together, though you are still married as husband and wife,
yes,
or otherwise we refer to such situations where you're not actually separated, you're not actually divorced,
yes,
but there is an intent not to cohabit together as a result of which parties are living together.
yes,
It will not refer to a situation where a husband is employed in a different city or a wife is employed in a different city, because there is an intent to cohabit, but
Okay.
for reasons of whatever your immediate circumstances, you are living separately.
Yeah.
That's not the 67 situation. Living
Yes.
separately or otherwise, who is living separately means not living in two different locations, but where there is an intent not to cohabit.
yes, yes.
If I may say so, the legislative history of that amendment or otherwise, it came in 2012. It was not there prior to 2012.
Can you just give us a small note of a page or so on that?
Yes, I can give you the legislative history of the addition of those words or otherwise. To the extent that I have knowledge of it, it may not be recorded anywhere, but this is a fact that it came in 2012. And my lord, if I may just tell you, its origin seems to be that when you file for mutual consent, you have to be living separately.
Right.
That's a condition for divorce by mutual consent. But this issue came for interpretation before the courts that what is the meaning of living separately? Does it mean living under two different roofs? Or can you live separately under the same roof? So the courts have held that you can live separately under the same roof. It goes to the intention that my Lord the Chief Justice said that we do not wish to cohabit with each other in the matrimonial sense. So even though you're under the same roof but living separately, this section will kick in.
It will kick in.
It will kick in just as mutual consent kicks in. So mutual consent also can be granted if the people plead that we have been living separately, though under the same roof.
So living separately is not that you stay in two different physical locations.
No.
You may be in the same physical location.
Yes.
But there is an intent not to cohabit together.
The intention to have conjugal relations
Has ended
ended.
for the present point of time.
Yes. And my lord, one of the reasons it was introduced, to my knowledge,
That came in Act 13 of 2013.
2012.
13. Act 13 was actually it was brought in 2012.
It was,
The,
yes,
the
it was
assent was early, maybe in January, February
Nirbhaya
2012.
amendment. It came after the Nirbhaya, after Justice Verma.
Right. 376 came in, 376B, with retrospective effect from 3rd February 2013.
It came in 83.
No, that was an earlier.
Earlier. No,
That was public servant.
No, Manoj, there
No,
was 76A which dealt with this, and it read intercourse by a man with his wife during separation. Whoever has sexual intercourse with his wife who is living separately from him under a decree of separation.
That's it.
Or
You're right. I got that. At the footnote to page 151, if you have got the same book.
what renumbered by
So
2013
376A
as it stood prior to in 1983.
stood as under.
Then it
So
gets
their
amended in
custom and usage is removed and lives this is brought in the
Right. So 376A, as it then stood, but it covered only under a decree of judicial.
Yes, my lord.
or
Yes.
custom or usage. Please see that.
Yes.
Yeah.
Or under any custom or usage.
Formality that is attached to it.
No,
It's
my
not
lord,
an
what was
informal-
Then
happening?
what they did was in
That was-
2013,
Custom.
there is removed custom and usage and said
Or
decree
otherwise.
for judicial separation or otherwise.
Well,
You got it.
It's not my place to
Yes.
comment, but the
No,
petition.
thank you. Thank you.
Therefore,
Place
not-
the legislative history a little before.
Therefore, the key, my lord, the key.
Have, my lords.
Key
It's
is
in-
intention, my lord. The
And
key
there are more of us to come.
and my lord, the problem arose
My
because of
friend unfortunately has started a world tour. We are into a European context.
But this is
I'm
Indian
coming to
law
that.
explaining, Mr.
So
Sushma.
no, I'll finish quickly now. 10 minutes, I finish. I
Explain
don't want to
to me,
take
no.
up your.
I am talking about Colin Gonsalves.
But,
not you.
but I'm on my legs.
Ma'am,
Manoj,
I'm sorry.
Manoj,
I think you were really referring to Mr. Gonsalves' written submissions, not about you, Mr. Singh.
Manoj, just one last.
Calcutta matter also, my lord, I am always, my lord, fearful of standing beside.
No, my lord, I'm on his side. In the Calcutta matter, we are on the same side. Why are you afraid of me?
For the first time, I realized that being opposed by her and being supported by her is the same thing.
That's a huge compliment to me, Mr. Mehta. A huge compliment. Thank you. But if I may just conclude
well
with
said,
one
Mr.
sentence,
Tushar.
my lord.
Well said.
The problem was decrees for judicial separation were taking forever. That was the issue. Why?
Mr. Singh, the Solicitor General is complimenting you for your fierce sense of independence.
Yes, my lord, I think he wants me to sit down, so I'll do that.
Mr. Jaising, but just give us, as Mr. Dave said, just if or anybody can, just one page of, the.
I'll do it. Manoj.
Please do that.
It was just so happened, I know this because at the relevant time in 2012, when the amendment,
It originally came in 83.
yes, 83.
Which said judicial separation, custom or usage.
Yes.
2013, the judicial separation is expanded by using the words or otherwise. Custom and usage goes out.
No, my lord, with respect, I'll repeat once again, the question is intention, as my lord put it, you do not intend to
Intended to
cohabit.
cohabit as husband and wife.
You want to live, you don't want that conjugality. That is the intention. That's why you're living separately. That was the intention behind introducing or otherwise.
So, my lord, I'll
What
finish.
else, Mr.
Yes,
Gonsalves,
yeah,
now?
I'll come to the end.
We'll look at your.
So, my lord, the first part, which I read out to your lordship, but I didn't read the judgments, it seems to be pretty well settled in the world, in constitutional courts, that the exception is unconstitutional. So there's a strong persuasive value that your lordships may agree to follow that line or distinguish it. Now, for India, a special argument was made at page 51 onwards, which is met by the UK Law Commission report, which studied the effects of the court outlawing marital rape, page 51. And exactly the same arguments were made in India. I'll just read this one page. First, my lord, that there should be a separate regime of sentencing for marital rape, that is A. And the report says there's no reason, no factual or legal basis for this. Second, that there would be humongous problems in prosecuting persons who engage in marital rape because it takes place in the confines of the room. They said no. C, there will be enormous difficulties of proof, evidence, proof in marital rape cases. The Law Commission said it doesn't seem to be any different from normal crimes. D, balance of credibility, that there'll be a single witness who's the woman who's been raped, the wife saying, they looked at that and said no. Next is, my lord, even if there's only one witness, who's the wife, courts would be capable of identifying testimony that it was in fact credible and acting on it. And finally, the wife would feel tempted to make serious allegations against the husband. They found that there was no evidence of that, even 10 years after the law was changed. Next, my lord, next page, and I'll finish very quickly. Page 52. The existence of an offense, this is very important, my lord, would itself tend to deter the conduct of marital rape. You would not need wives to go to courts and punish their husbands. In fact, the finding was that wives are very fearful of prosecuting their husbands even after, my lord, rape takes
Have you seen that?
etc., etc. My lord, these are, your lordship will see this. Page 53 is a new aspect, namely, in the UN, where, my lord, it's called the Universal Periodic Review, where countries are subjected one by one on aspects where the national law has not met international standards. And on marital rape, my lord, we were found to be seriously lacking. These are the countries which make recommendations in the UN. very politely, my lord, in a very civil,
That's all right.
saying that we, yes, Lord.
It was a constitutional.
Finally, my lord, turn to the Nepal judgment, just a paragraph from the Nepal judgment on how the removal.
Where did we get the Nepal judgment?
Yes, my lord, page 23 of the same,
All right, we'll look at it.
page 23.
We'll look at it.
That criminalizing rape, marital rape, purifies the institution of marriage.
All right, we'll
It doesn't undermine and denigrate it.
So
Grateful, my lord.
what, thank you, Mr. Vansa.
Yes, Lord, grateful.
What we'll do is we'll break here. It's about 3:50. Mr. Shankarnarayan, we'll hear you next. After Mr. Shankarnarayan on this side, who is going to argue?
I just wanted some clarity. If your lordship would want me to address the interpretation so that it goes
I
along.
think so, yes. But without going into the facts of your case.
Yes.
But we'd like your assistance because we have.
Can I just clarify one thing?
On this side.
Could do
Because
that.
there was a split decision in the High Court, there is a appeal coming the other way as well, against, which will possibly argue with the respondents. Technically.
So we are dealing with the 32 petitions essentially. But
Essentially, the proposition which is being tested, my lord,
That's right.
SLP
So
or
about half an hour
SLP.
from Mr. Shankarnarayan on Tuesday.
Then I'll just
And
read.
then, Mr. Shankarnarayan, you have circulated your submission?
I have,
So over the weekend, we'll,
it's very detailed.
speaking for myself, I have long flights over the weekend, so they're always an opportunity
reading
to
material.
read what,
Your lordships may
one
not.
is either
my lord.
typing one's
Let me just-
judgments out or reading on.
Your lordships may not waste, my lord, flying time on reading this, my lord. There are better things, my lord, in.
I've
for read-
actually made it quite entertaining with pictures and stuff, so it may be more interesting than Mr. Mehta thinks it is.
Oh, I see.
And secondly,
Subject like
the
that.
canvas, the canvas,
To get it wrong.
the canvas is actually a little wider.
That's why we look at your
Many more,
submission.
including these sections 67 are all under challenge in this.
So we'll
Yeah.
closely read your written submission.
Right.
So now on this side, Mr. Shankarnarayan, followed by Ms. Jaising on interpretation.
Yes.
And after that, then the solicitor, you lead solicitor? Okay.
There's one thing which was fallen from Justice Pardiwala, specifically on consent. The first clause is against her will.
Against her will.
So will and consent, that is going to cause considerable, from our side, the arguments are going to be on that. That may be kept in mind by your lordship on that.
And irrespective of your mind, if you want to take 10 minutes to just highlight some of the important issues, the ways which you are.
Even what he said will.
It's the election, seal number 30 for last edition.
Section 34.
Who's appearing in this matter?
Item 34.
Yes, Lordship. I am.
What are the reliefs which you are seeking in this matter that we should injunct the Haryana government from taking oath?
Lordships,
They've taken oath.
Lordships, my prayer is here कि I filed the presentation, Lordship, before the election commission, give the directions, this pending application decide in the time-bound manners. Is in Lordship, I was saying that early morning, Lordship.
Kind of petitions are these?
Okay, Lordship.
Direct the ECI to conduct the re-election in 20 suspicious Vidhana seats.
Yes, Lordship, because there is the 70 to 90% battery has been charged found out the election commissions as per the laws, Lordship, which is already annexed. In these presentations, Lordship, same entire.
Items 30 to 32.
Taken on board.
My lords, with your kind permission, may,
Just one second.
may
Lord, item 28,
My lords, I sent
Fresh
my
matters may
it can be kept
fresh
on.
matters may remain, my lord, on board.
Yes.
32.
The fresh matter.
The Rajasthan examination.
Lord, 28, be kept on Monday, my lord.
That is your, that NHI.
NHI matter, my lord. Tomorrow, section 9 is being pronounced.
NHI का seat number 28 है सोमवार को लगा दो.
my lords, with your kind permission, may I mention one diary number? Yes, my lords, I've been e-filing it, like I have done the online mentioning, I've wasted a day.
When was the impugned order passed?
It was on 2nd of August, 24.
There you are.
Lordship, one submission, my lord. Item number 29, your lordship, may be taken as the first item tomorrow, my lord. Tomorrow is the last day for allotment.